I don't have to deliver the results here, right? Because I don't think I'm really in a position to decide on the merits of the case given certain technical constraints here. But I'll be more than happy to give some comments here. Okay, thank you. So thank you both teams, prosecution and defense. You both did a great job. And I would particularly like to mention the prosecution's efforts in establishing the elements of the crime, of the charges set forth in the materials here. And I would like to compliment the defense for establishing the elements of the affirmative defense in this in the materials here. I'm not going to say who won this case here. I'm not going to say whether or not the defendant is guilty, but I would like to say that the prosecution and the defense both did a great job in what they should do. However, there are several points I would like to mention here that would probably help that would probably be beneficial to the participants here. First of all, the prosecution perhaps could try to attack more to attack the affirmative defense part of this case more. The affirmative defense in the materials here, although it might appear bizarre to some of you, but in any event, that is a defense in this case that could acquit the defendant. So to convict the defendant, the prosecution in reality would have to, when the affirmative defense is raised, the prosecution would have to persuade the court that the elements of this affirmative defense were not met. And I've seen the prosecution trying to discharge the defense here, but that is perhaps something that we can try to do more here. And as to the defense, very often the defense would spend most of their time attacking the prosecution's story, saying that this and this element of the crime is not met. This is correct from a purely legal point of view. The defendant does not bear the burden of proof. However, we do have to remember that all cases, whether heard by a professional judge or a jury, after all, are all tried by human beings. And human beings would tend to believe a party's case if the story appears convincing to them. So indeed, the prosecution has to have a story. As for the part of the defense, in reality, the defense also, it would also be better for the defense to have a story on their side as well. Indeed, the defense could say from a purely legal point of view that, well, this and that element of the charges are not met. Perhaps it would say that the affirmative defense here would acquit the defendant. However, even with such an affirmative defense, it is still, I would still encourage the defense team to establish a more complete story. For example, the story might be about a father with such faith in his religion, which, however, led to a regrettable result. You need a line of your story. The story is not only helpful in terms of convincing the decision maker, in that case, be it a judge or a jury. A story is also helpful in formulating your questions, especially directed against the hostile witnesses. When you ask questions, when you conduct cross-examinations, you would have to follow a line of the story, so your questions stay on track. And so this will lead me to my next comment concerning cross-examinations. When we conduct cross-examinations, we are basically asking, throwing questions at hostile witnesses. So during cross-examination, it is mostly the case, and in practice as well, that lawyers or prosecutors would only ask questions to which they know the answer. Cross-examination is not a chance for a litigant to learn more about the fact. Cross-examination is a process during which you present your story before the court. So when you ask a question during cross-examination, be sure that you know the answer to that question. And that would guide us to a often said tip about cross-examination, which is to avoid open questions. We're not saying that open questions should not be asked during cross-examination, but they have to be treated with extreme caution, because open questions are often questions to which you don't know the answer. If you don't know the answer to a questions, you will not be able to predict what will come out of the mouth of the hostile witness. And given the hostility of that witness, he or she probably would not say something in your favor. Even if he or she does not know the answer to that question, even if factually speaking, the answer should be disfavoring your opponent, given the hostility of that witness, he or she will try to make up a story that supports his or her team. And in that case, that might necessitate quarreling with the witness, which is certainly unadvisable in a mock trial competition and indeed in a real court of law. And during cross-examinations, be sure that you as a lawyer or as a prosecutor are controlling the entire process. So it would be good to stop the witness when appropriate. Indeed, in some circumstances, you wouldn't be able to stop the witness. In some circumstances, the judge would allow the witness to finish his or her statement. But that would be something that we can attempt to do. That would be something that, if successful, will support the result of your cross-examination. And the next point I would like to mention is when you examine a witness, especially an expert witness, it would be good to start by establishing the qualification of that witness. For example, in this case, I see at least two experts in this case. On the prosecution side, Dr. Joshua Sapp is an expert. So before starting the examination, you probably would like to establish why Dr. Joshua Sapp is qualified to say what he is about to say. The reason may be founded in his expertise in this field. So you might want him or her to briefly to introduce what he had done in the past, how he was educated, and his experiences in this field. As for the defendant, the pastor, the pastor on the defendant's side would be the expert in for the defendants. This is relevant because the affirmative defense, one of the elements of the affirmative defense, is that the treatment must be in accordance with the tenets and practices of a recognized religious method. So probably you would want the pastor on the defendant's side to tell more about why he is qualified to establish the tenets and practices of that church, of that religion. And And next, I would like to mention, and somehow relevant to what I just said regarding the qualification of the witness, which is a point regarding attacking a witness. When we say attacking a witness, it is indeed helpful to say that what that witness said is not true and what he or she said is unable to support the story of their side. But very often we hear participants in mock trial and in real court of law as well, attacking the credibility of a witness, attacking the qualification of a witness. During mock trials, many participants would try to convince the court that a particular witness is not trustworthy or is a bad person. The result of a case might be his or her fault. These are all points that we hear in mock trial cases. And I think I can categorize these attacks into two main subcategories. The first one is the attack against the qualification of a witness. For example, what the witness has heard or said is not actually what he or she observed on his or her own. It might be speculation. It might be something he or she heard from someone else. This is often a powerful. This will be a powerful point in a case, because this directly links to the qualification of evidence. Another type of attack is against the credibility of a witness, and often these arguments are directed against the character of a witness. It is often stating that this witness did something wrong, and the result of this case is largely the fault of that witness. This kind of argument can be made, but are very often less powerful than arguments against the qualifications of the witness. I'm not saying that we should not make this kind of argument, but I'm saying that we will probably have to control the level of argument and the frequency the frequency with which we make this kind of arguments. And finally, I would like to talk about objections. I think both teams today made very good tries on objections, and I would like to say that don't get frustrated because the objections are overruled. The objections may be overruled, but indeed on legal grounds. But it is also possible that in the gray area, a judge might want to hear more from the witness and accordingly overrule an objection. But again, I would like to reiterate that just don't get frustrated if an objection gets overruled. In fact, very often objections get overruled. So as long as the objections are not entirely meritless, I would encourage both teams to continue your efforts today. You have done well in raising objections today. Objections not only stop disfavoring statements, sometimes they buy time for your witness. Sometimes they give the witness more time to think about what he or she is about to say. And particularly, I have heard a lot, many times, the objection of irrelevance. Irrelevance is, I think, one of the most frequent objections during mock trials. But it is also one of the most frequently overruled objections in mock trials, because it is very easy to establish some sort of relevance of a question to a case. So when you raise an objection of irrelevance, you have to be ready. You have to be prepared that your objection probably will just buy some time for your witness, and it probably will not be sustained. So that is just something that I have observed since my participation in mock trials and my observations of many subsequent mock trials. And regarding objections, I would like to also encourage the team to raise objections during direct examinations. One of the important functions of objections is to stop questions and thus answers to that question. And during direct examinations, a team would be establishing its case. So if you could stop a question during direct examination, very likely you will be able to stop the team's establishment of its case. And an objection that you can try during direct examination is the objection of leading. Leading, plainly speaking, in plain languages, is feeding word into a witness' mouth. However, for example, if a counsel asks his or her witness during direct examination this question: so, Mr. X, you were at the cinema on the 1st of May to meet Mrs. Y. Is that correct? That would be a leading question, because the witness will only have to answer correct and to establish the content of that question. So it is basically the lawyer making that statement and not the witness. That is the purpose of the leading objection. But also be reminded that leading is allowed in cross-examination, and leading questions are encouraged in cross-examinations from the point of view of participants in mock trial competitions. Namely, I think we've previously mentioned that when you're conducting cross-examinations, you want to avoid open questions and you want to know you want to make sure you're asking questions to which you know the answer. So leading questions are very good in cross-examinations. And on the other side of the story is during direct examination, you can try objecting on the ground of leading, and sometimes that would work. And when that works, it would be very helpful to your case. So I think that is pretty much my part, and I think I'll be happy to answer any questions from the participants online.
Okay. Do everyone have any questions from Vietnam to Consular Sue? Okay.
I'd be happy to answer questions after this video conference as well. So it's fine.
Okay. Well, go ahead, Mr. Evans.
Hi. Yeah, there aren't any questions at the moment, and we really appreciate all the feedback we're getting.
I'm sorry. What was the question?
We don't have any questions at the moment.
Oh, they didn't have any.
Thanks for the
Okay.
feedback. We appreciate that. Can you hear me or what?
Well,
Oh, it's me now. Can you hear me?
yeah, we can hear you now pretty good. Go ahead.
Yes. I apologize for that, for the sound problem today.
Okay. I think they want to, if you were going to make a decision really quickly, Roy, who would you decide that won the case? I think that's what they want to know.
Okay, if I have to make a decision now, I would find for the defense, largely because the burden of proof for the affirmative defense is lower than the burden of proof for the elements of the crime.
Okay. Yeah.
I mean, if I have to make a decision now, I mean, this is a very difficult decision given the good preparation and performance of both teams.
Yeah, I think what's really hindrance here is that you couldn't hear for some particular reason with a microphone echoing and stuff on some, because the first when we got to Don Colson's cross-examinations, when you could start hearing everything really well. And I thought that was probably the best exchange. That was actually really good. Now let's hear from some other countries a second. Pakistan, can you hear us at all? And could you tell what you got to see? Okay. Indonesia, can you were here the whole time. Could you unmute and tell the people what you thought, please?
I think that what we have to do is only for internet connection, because what I heard, I cannot anything do for clearly enough the case, but the moderator perhaps could be make me know it about how to decide in a court situations. I just know it that the court is so amazing. I think I would like to know about, deeply about the court consistently. Perhaps That's what I know. I just
Okay.
want to know.
Very good. No problem.
Like that.
I'll let Roy answer this question a second. I want to have Vietnam ask a question, but Roy, I know I met you back in 2009, and I've shared this with you, but I'd like to share it with everybody else. Roy and his teacher were competing in a competition we had with, I think, about 13, 14 other schools. And they were going against a school from Canada. And we had a series of partners from a law firm here in Austin, Texas. And it was the second largest law firm in Austin, Texas at the time, largest in Austin, Clark Thomas Winters. And they, after, when Roy got done with his, and he was a sophomore that year, I think, when they got done with the whole mock trial, one of the partners turned to another one and said, off the mic, he said, well, this gentleman is going to be a tremendous lawyer one day. And you can actually see people that, you know, even at a very young age, stuff like this is absolutely excellent. Roy would be able to stop people in their tracks when he's talking about cross-examination. I actually had one where a person couldn't speak for about 2 minutes. So this is a pretty, yeah, thank you. I knew exactly what grade he was in. Okay. This was a pretty interesting thing in a lot of ways. And considering that we are trying to work with people that English is not their first language, and they can speak so well. And if you can speak so well and you can think in that language, you can actually learn languages excellently. Roy, why don't you explain a little bit about how this can influence your life, so you might could tell the students a little bit, okay?
Okay, thank you, Mr. Cunningham, for your kind words. When I participated in the mock trials competitions, I would say pretty much a decade ago, during these competitions, I have had the chance to go over these materials and to formulate my arguments using English only. So even in Chinese, mock trial competitions are not easy, and preparing for these competitions in English trained me in two aspects simultaneously. Firstly, my ability to think and to argue in English, and second, my interest and, to some extent, profession in law. How this influenced my life, I would say that the mock trial competitions at that time made me who I am now. These mock trial competitions inspired me to pursue a law degree. So after high school, I entered law school in Taiwan. After law school, I passed the bar exam, and now I've started working as a lawyer. About 2 months ago, when I was in a court hearing in one of the criminal cases handled by our firm, I was thinking about what it was like 10 years ago when I was in high school, when I was participating in these mock trial competitions. And to myself, these mock trial competitions really made me who I am now, and it guided me to what I do now. In this law firm today, I'm handling all kinds of legal matters, from litigation to commercial deals, mergers and acquisitions. And all of these started from what I did in high school for these video conference programs. Really, it is these competitions, these mock trial competitions, that inspired me to pursue what I'm doing now.
Okay.